Welcome to the latest episode of Risk Settlement's podcast, Alternative Litigation Strategies, where I interview leaders in the litigation industry from all over the country. On this program, we discuss the latest trends and developments that are currently happening in the world of class action litigation, as well as other types of commercial litigation. I'm your host, Kevin Skrzysowski, with the litigation consulting firm Risk Settlements, and today I am very pleased to be joined by Alex Krasovec, a partner in the TCPA Compliance and Class Action Practice Group in the Los Angeles office of Manatt, Phelps and Phillips. Alex, it's a pleasure to have you on the show today.
Glad to be here, Kevin.
Now, today, Alex, I know we're going to be discussing state Mini-TCPA statutes, but before we get to that, can we just start by having you tell us a little bit about your practice and your career at Manatt?
Of course. I am a partner in the TCPA practice group, as Kevin mentioned. I am one of the groups within a dedicated consumer protection, advertising, and competition group at Manatt. And I, along with our team, which expands across the country, work with clients of all sizes and in every industry on compliance and in class action litigation defense. A large part of that practice is TCPA and state calling law restrictions. And I've been practicing in this area since before the FCC's omnibus in 2015. So I've seen the full spectrum of TCPA interpretation, enforcement, and trends over this time. And today, I know we're going to talk about one of the most recent trends, which is the increasing popularity of the state Mini-TCPA.
Now, in addition to your practice, you also do a lot of speaking at conferences across the country. I know you recently spoke at the Contact Compliance Center's 2022 TCPA Summit on state Mini-TCPAs, and I believe the title of your program was The New Frontier. Let's start by just having you give us an explanation of what are the state Mini-TCPAs and what impact did the Supreme Court's decision in the Facebook versus DeGuid case have on the development of these state laws?
Well, state Mini-TCPAs is kind of a colloquial way to refer to state laws that regulate calling activity. But at a very high level, what they do, they are Telephone Consumer Protection Act equivalents at the state level. So they often consist of several statutes and they all regulate kind of different things. But at bottom, the idea is that the same activities that might get you in trouble with the Telephone Consumer Protection Act at the federal level could also get you in trouble at the state level. The issue now is that after Facebook, the Supreme Court's decision on the TCPA, there is a lot more room for state laws to come into play. And the main reason for that is because the Facebook case held that a random or sequential number generator is required for a system to be an automatic telephone dialing system, or ATDS, under the TCPA. So at a very basic level, what happened is a lot of equipment that used to be regulated by the TCPA may no longer be. And because of that, there are now calls that could be permissible at the federal level that are actually regulated at the state level. And so requirements at the state level now are triggered where previously a business might comply with the federal TCPA. Now there is a focus on state law compliance needs.
Very interesting. So it sounds like the federal law was narrowed a bit, but it opened the door for potential liability under certain state laws.
That's correct. And, the funny thing is that many states have had these statutes on the books for years, but they didn't get a lot of attention because the TCPA had been interpreted so broadly for most of the last decade. So companies that were TCPA compliant could often also be simultaneously state law compliant. So people kind of forgot that state laws existed. But after Facebook, that's become a new focus. And there's been a lot more attention at that level, both with existing statutes and then also with amendments and new legislative activity.
Okay, so now let's go into which states actually have these. I know they're colloquially referred to as state Mini-TCPA laws. They're actually like Telephone Solicitation Act laws, but there's been some marquee ones that have been enacted recently. What states have gotten into this Mini-TCPA mix so far?
So there's definitely been some recent activity, and we'll talk about a few of the select states where that occurred. But as a premise, I just want to say this fact, which I think blows a lot of people's minds, which is every state regulates calling activities to some extent. Now, some states regulate it more than others, but to give you an idea of the kinds of restrictions that are out there are states that regulate telemarketing. Actually, all of the 50 states do. There are do not call restrictions. Some states maintain their do not call registry or their own list separate from the national registry. States regulate automated calls, pre-recorded calls, caller ID manipulation and call blocking. And then there's a lot of states, a majority of them, that have private rights of action to enforce violations of those calling statutes. So the bottom line is state law compliance can be very complex. So anyone calling nationally or even just across a few states has to be aware that they could be tripping those state law statutes with their activities.
I'm really glad that you raised that point. I think you're correct. I think a lot of people don't know that there's already been regulation on the books in all states that govern telemarketing. Do not call lists the hours you can call. I actually did telemarketing when I was in high school back in the Stone Ages, and I remember there were certain hours you could not call. But as it pertains to those laws compared to what people are referring as to state like Mini-TCPA laws, which I'm guessing are more stringent, have more penalties, have more private rates of action, what states have gotten into that mix, or what was the first state that created a Mini-TCPA law, if you will?
So the first state post-Facebook to really build out their telemarketing laws in reaction to the statute was Florida. And Florida actually has two statutes, the Florida Telephone Solicitation Act and the Florida Do Not Call Act. And their legislature amended both of those statutes to strengthen them and provide more teeth. What many of us believe is they did this to backfill the perceived recession of the automatic telephone dialing system definition by the Supreme Court.
Right. So to further our discussion, there's already these telemarketing acts and these solicitation acts on the book, but they are strengthened by these enhanced laws. So starting with Florida, and then I want to move into a couple of the other states. So what impact did the new Florida law have on, let's say, call exemptions or some of the prior express written consent requirements and the private rights of action?
Well, Florida was interesting because what they did is they removed certain previously available exemptions, which then made more calling activities subject to the statute. They imposed broader restrictions than the TCPA by adopting this language that is referencing an automated system for the selection or dialing of telephone numbers or the playing of a recorded message. So basically backfilling the space that had been created by the Supreme Court. And then, of course, Florida has a private right of action for individuals to enforce violations that mirrors the TCPA. So a violation could cost $500 to $1,500 per violation under the Florida statute.
And just to get a little granular for a second, was there additional regulation on like the time of day, the number of calls that could be made?
Yes. As I mentioned, there are two components here with the Florida changes, and one of them was a portion of the statute that regulated certain calling activities based on time of day. And what the legislature did there is they actually reduced the time frame when you can make calls to be 1 hour less than what the TCPA permits. And then they put a cap on the number of telephone solicitation calls that can be made in an hour to 3 within a 24-hour period. And then there was also some changes relating to caller ID blocking, basically prohibiting that and prohibiting deliberate spoofing to conceal the true identity of the caller. Now, those provisions also have their own private right of action, but it's only for actual damages, punitive damages, and attorney's fees. It doesn't include the $500 to $1,500 per call.
That's very interesting. So as we referenced at the beginning of the podcast, these state laws are being created. And what we've seen here in our first example in Florida is that there's the removal of some exemptions, but then there's the addition of some regulations, making the state law stricter, in essence, than the current state of the federal law.
That is absolutely correct. And as a result, Florida became a hotbed for activity in the last year since this law went into effect. It has seen quite a bit of action. I think at my last count, which probably at the year mark for the statute being in effect, basically July of 2022, there were 42 actions that have been filed under that statute. So it became a really hot place to file this kind of litigation.
So you're saying 42 cases in 1 year?
That's correct. And what makes it really tricky is that the Florida statute's not so well fleshed out. So unlike the TCPA at the federal level, where there are tons of cases out there that courts can look to as they interpret the statute, that's not the case in Florida. So everything is a novel issue, and a lot of the language in the statute is very broad and open to a lot of different interpretations. So it does really increase the risk associated with the kind of class actions and litigations that you're seeing in Florida.
So it sounds like there is a lot of litigation to follow that's going to interpret the law. And I bet that you would expect additional litigation to continue to flood in around the Florida law.
I do. And what I think is it's almost like a microcosm of what happened with the TCPA. For those of us who've practiced in this area for a long time, we recall when TCPA lawsuits were probably the worst news a business could receive. And It was business ending as far as the amount of damages once you multiply them across the class. And I do think we're seeing a bit of that at the Florida level, and especially for companies who were caught unaware because of this shift in what could potentially be regulated calling equipment. Many folks had been acting based upon the TCPA and maybe weren't prepared for this type of change. So they didn't have the kind of consent they needed to begin with. So when the law went into effect, all of a sudden, now it's like very much of a gotcha. And businesses were caught a little bit flat-footed because of how quickly this went into effect.
Okay, so we definitely have a lot to pay attention with when it comes to Florida. Let's move on and talk about some other states. So the next state to jump on the Mini-TCPA train, I believe, is Oklahoma with their Telephone Solicitation Act that was enacted in May. Now, this one I know doesn't go into effect until November, so there's a lot of litigation. We just have the language of the statute to look at right now. Can you tell us a little bit about the Oklahoma law? And now, is this more or less restrictive than the Florida law? And then how does it compare to the Florida law? And then how does it compare to the federal law as well?
At a very base level, Oklahoma was almost a copy paste of Florida. Much of the language tracks. There's a couple of nuances there. And so you obviously have to review the requirements in that state too. You can't just comply with Florida, then also satisfy Oklahoma. But much of the language tracks. And I think just like Florida, what we have is a situation where it's more restrictive than the federal level. And we also have a statutory damages provision for a private right of action that is similar with this $500 to $1,500 per violation.
Okay, so Oklahoma seemed to copy Florida. But then in June of this year, we saw that Washington state enacted their Telephone Solicitation Act. So how did Washington then compare to Florida and Oklahoma? And are there different exceptions to this law in that state?
Yeah, so Washington also jumped on the bandwagon. Now, Washington made amendments to an existing law. What it does do that is similar to Florida and Oklahoma is it does have a private right of action. Its recoverable damages, however, are much lower. It permits $100 a violation, but there's also an attorney's fees and costs for the prevailing party. So that's in there. It also imposes some kind of odd content requirements and calling activity requirements. And what I mean by that is there's now a time limit of 10 seconds to terminate a call upon the request by the called party to end the call. And then before that happens, the caller has to also inform the called party that their information will be removed from the caller's list for the period of 1 year. So there's more nuance there. And this is actually a great example of a situation where the state laws, they're not identical. Even though many of them share a lot of the same attributes, they are not the same in what they require. And so it's very important to be attuned to these kind of odd, differing requirements between states.
That seems like some pretty obscure hyper-technical requirements that are in the Washington law.
Yes, it is interesting what legislatures decide to focus on. And that was one of the nuances with Washington. There is another nuance, which is that Washington does have exceptions that are not present in the Florida and the Oklahoma laws. And one of those is that it does recognize that calls made in response to a request or an inquiry, and that calls regarding items purchased by the called party from the company in the prior 12 months are permissible, not defined as telephone solicitations that would be subject to these requirements. And there's some other not-for-profit exceptions, and they do address business-to-business contacts within their exceptions. So it is maybe a friendlier, if you could call it that, law than Florida and Oklahoma, but it is definitely different in its own way.
Those are some excellent points that you raised. Now, we work with defense attorneys all the time, but I'm not a defense attorney, but those exceptions seem rather reasonable to me.
Yes, I think so at a high level. But then, of course, what you'll find is things become rather complicated quickly when you're in a litigation. So, with the B2B contact exception, I expect that we'll see something similar to what we see with the TCPA, which is there's dual purpose arguments about someone's cell phone being both a business line and a personal line. And so now it's not technically a B2B contact. We see that kind of argument happen. So everything can look very friendly at a high level when you're reading the statute, but it can become difficult to deal with when you actually apply the facts.
So nonetheless, still subject to litigation. And I think with what I coined as hyper-technical requirements earlier, I think that's going to open a bit of a floodgate of litigation as well. But the one thing that is interesting is that the statutory penalty is much lower, decreasing from $500 to $100, which actually makes a nice segue to my next question, which is around the state of Michigan. And most recently, Michigan introduced its own Mini-TCPA, which contains some provisions that aren't included in the other Mini-TCPA state statutes. And one of them includes much stiffer penalties. Now, I know the Michigan law, as it's introduced, is very new, but can you take us through some of the stark differences, including some of these stiffer penalties that they are proposing?
Michigan really seems to be using a bludgeon here. The civil penalties there are very, very intense. In some cases, they go as high as $100,000 for persistent and knowing violations. And it also includes a robust attorney general enforcement provision with notice provisions and opportunities and other obligations that could result in further violations for failing to follow the procedures. Michigan also provides a private right of action, as you noted, for individuals, and that allows $1,000 per violation and reasonable attorney's fees. And I don't want to brush over the attorney's fees because that actually is not present in the Telephone Consumer Protection Act at the federal level. So this sort of inclusion in any of these statutes actually makes them more tempting for plaintiffs' counsel to use when they are deciding where and what statutes to file suit under. So that attorney's fees piece is unfavorable, but it's also one that I recognize is present in the other statutes.
But that statutory penalty is catastrophic for businesses, even if they made a handful of calls.
So the civil penalties piece is interesting because a lot of that goes to what the attorney general can recover. And so it will depend upon how active the attorney general is. And if this did end up becoming a law, which right now it hasn't passed the House, so we don't know yet whether that will be the case. But there are states that are extremely active at the attorney general level, so it is a real concern.
I can absolutely see that. Well, this is a very interesting conversation around what has occurred and what is occurring in Florida and Oklahoma, Washington, and Michigan. Now, do you expect other states to go down this road? And is this a coordinated effort by the plaintiffs' bar to forum shop, or is this just something that is growing organically and legally?
Well, if you look at the past year, it does seem likely that the state law trend will continue, especially if we see states like Florida and Oklahoma surviving constitutional challenge on their statutes. Also, this state Mini-TCPA approach seems to be pretty constituent and lawmaker driven. I think for those of us who recognize that politically a lot of things create differences across the aisle, one thing that Americans seem to agree on, at least in the eyes of lawmakers, is that what are called robocalls are a hindrance or an annoyance, and they are not wanted. So I think a lot of the legislative activity is being driven by that. Of course, the plaintiff's bar directly benefits from the laws to the extent that they provide additional avenues for recovery, and a number of the statutes also permit attorney's fees.
And definitely a lot to keep an eye on, and it actually brings me to my last question. And in your answers to several of my questions, you've already provided some cautionary tales. So let me just come right out and ask, given the changes to the federal law and the development of a myriad of these state laws, what advice do you give to your clients, especially your clients that participate in any kind of sales or marketing activity, to remain compliant with all of these laws and to avoid potential litigation?
Businesses really need to consider outbound calling a trigger. So if your company or a vendor on the company's behalf is making telephonic outreach, whether that's by voice, recorded call, artificial intelligence, text, or fax, that needs to be flagged for compliance review. The other thing is the TCPA is important, but it's not the only statute to be concerned about, as we've discussed today. So state laws regulate a lot of things that the TCPA does not, and they tend to be a lot more nuanced. So a few things I would say is, don't try this at home. You should seek knowledgeable telemarketing compliance counsel, just because there's so many varying requirements and every company's needs are different. Most often, a one-size-fits-all approach isn't going to be the best play. And it also can really impact ROI, which you will see as you start to just tick off what's permitted in certain states and not in others. So compliance can be tailored to the business needs and the goals, and the calling strategy can be structured to avoid tripping some of the requirements. So I do recommend you hire knowledgeable counsel for this. But there are tools you can use to help identify where issues might arise, like knowing which state laws might apply to the business practices. If you keep an eye on our website, we have lots of resources there, including webinars that are previously recorded on the state laws that are coming into effect. And then we also are going to be coming out with a state law manual, which just provides a complete overview of the type of activities that are regulated in every state. And then once you know that you have tripped one of these laws, then you can talk to your attorney and work through how best to deal with that.
That all sounds like great counsel and advice. Well, Alex, that's really, unfortunately, all the time that we have for today. It was a real pleasure having you as my guest. And I want to thank you for your time and all the valuable insights that you shared with me and shared with our audience today.
Kevin, this was a blast. As always, I'm a little bit of a nerd in this area, so I love talking about this with you. And, I just want to add that if anyone has questions, I believe you're sharing information with everyone in the podcast about how to contact me, but
Absolutely.
You can reach me at my email address, akrasovec@manatt, MANATT.com. And you can also check out the Manatt.com website, where we have a TCPA page. All of our resources are there. And of course, contact information for the team.
That's great. Thanks again. And so just so I'm clear with the audience, so all of the recordings of different conferences and thought leadership and materials that you have can be found on the Manatt website?
That's correct.
Wonderful. Alex, thank you again. It was a real pleasure. And of course, as always, I would like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, or anywhere you listen to your favorite podcasts. If you'd like to listen to a recording of today's program, or if you would like to learn about litigation risk transfer solutions such as class action settlement insurance, which effectively transfers the financial risk away from businesses who are actively defending TCPA litigation, please visit the Risk Settlements website at www.risksettlements.com. And you can always reach out to me directly at kevins@risksettlements.com. Until next time.